Good afternoon. I'm Brian Frazelle, Appellate Counsel at the Constitutional Accountability Center in Washington, D.C. Today, the Supreme Court issued its decision in one of the most important cases that the court heard this year. The case is Saylor Law versus Consumer Financial Protection Bureau, or CFPB. And the question at stake was whether the structure of the CFPB is constitutional. And today, the court said no. It ruled that the CFPB's structure violates the separation of powers. Specifically, the court ruled that the CFPB's structure is unconstitutional because the president can fire the director of the CFPB only for good cause, not at will. Now, this was a sharply divided decision where the court's conservative majority of 5 justices ruled against the CFPB, while the 4 more liberal justices dissented from that ruling. CAC filed an amicus brief in the case on behalf of current and former members of Congress. Those members included former Senator Chris Dodd and former Representative Barney Frank, who were the lead sponsors of the legislation that created the CFPB, the Dodd-Frank Wall Street Reform Act of 2010. Now, although this case has not received as much media attention as some of the other major cases the court heard this term, it's an incredibly significant decision. And that's because this case is about more than the CFPB. It's about Congress's power to design the federal government in a way that best serves the needs of the American people. So today's decision is extremely disappointing for that reason. Not only does it harm the important work of the CFPB, but more broadly, it restricts Congress's ability to try to solve the nation's problems. The immediate result of the decision is that while the CFPB can continue to operate, it is no longer an independent agency. Before today's decision, the president could fire the director of the CFPB only for specific reasons that were set forth in the law: inefficiency, neglect of duty, or malfeasance in office. But now, after today's decision, the president has the power to fire the CFPB director for any reason. So the president can now fire the director just because the director does not share the president's policy preferences, for instance. In practice, this means that the president will be able to dictate the CFPB's policies in the same way that he can dictate the policies of his own cabinet departments. Now, for some quick background, Congress created the CFPB after the financial crisis of 2008. And in fact, the Bureau was intended to prevent the very types of abuses that caused the crisis. Previously, there was no single agency that was devoted to consumer financial protection, which is why we saw the spread of abusive subprime mortgages, which led to the financial crisis. So Congress created a new agency, the CFPB, and it gave this new agency the mission of protecting Americans from harmful practices of the financial services industry. And Congress also decided that the CFPB needed 2 key functions in order to best do its job. First, Congress decided that the Bureau should be led by a single director. Now, it's true that most independent agencies are led by boards or commissions, but those kinds of multi-member bodies are susceptible to gridlock and delay. Second, the director, Congress decided, needed to have some level of independence from the president. And that's important so that the director can make decisions based on his or her expertise, and so that the director can have the freedom to enforce the consumer protection laws vigorously. But the Dodd-Frank Act also made the CFPB director accountable to the president. If the director neglected his or her duties, or was inefficient, or engaged in malfeasance, then the president could fire the director. And it's worth pointing out that since 2010, the CFPB has been very successful in achieving its mission. It has reined in many abusive financial practices and has recovered billions of dollars for defrauded consumers. But in today's decision, the Supreme Court ruled that the Bureau's structure violates the Constitution because the president cannot fire the CFPB director at will. So I would like to note a few key points about the decision. First, the decision departs from almost a century of Supreme Court precedent. Now, the court established long ago that when it comes to regulatory agencies, Congress can limit the president's power to fire the leaders of those agencies. And that doesn't infringe on the president's constitutional powers. But today, the court reinterpreted what all that precedent means in a way that significantly cuts back on it. So today's decision says that the Constitution gives the president the power to fire officers at will, and that there are only some limited exceptions to that rule. Second, today's decision ignores constitutional text and history. The majority opinion is a pretty egregious example of cherry-picking evidence that supports its result while ignoring contrary evidence. As we explained in our amicus brief, and as Justice Kagan explains in her dissent, the Constitution says nothing about the president's ability to fire federal officials, like the CFPB director. And the historical record clearly shows that when the Constitution was ratified, there was no consensus that the president had any constitutional power to fire officers at will. But that is the unwritten rule that the court majority established today. Third, today's ruling will likely diminish the effectiveness of the CFPB. And that's because the decision takes away the Bureau's independence and it allows the president to fire the Bureau's director at will. This will make the CFPB subject to the policy whims of the president. So, for example, if the current president doesn't like consumer protection laws and doesn't want them to be vigorously enforced, the president will be able to strong-arm the CFPB into falling in line. And then finally, the implications of the decision are even broader, going beyond the CFPB. The decision limits the ability of Congress to design federal agencies in the way that will best achieve their missions. And the ruling may also threaten the future of other agencies that already exist, whose independence is crucial to their functioning, like, for instance, the Federal Reserve. Even though today's decision only deals with the CFPB, the reasoning that the court adopted may open the door to litigation challenging these other agencies and their independence. And I'd like to, conclude by quoting from Justice Kagan's comments in her dissent from today's decision. She wrote that throughout the nation's history, the Supreme Court has left most decisions about how to structure the executive branch to Congress and the president, acting through legislation. But as she explained, today's decision is an example of second-guessing the political branches based on rules that are not found in the Constitution. And because of that, Justice Kagan wrote, the court today fails to respect its proper role. For full details on this case, as well as the opportunity to read the brief that CAC filed, you can visit our website at www.theusconstitution.org, or you can click on the link in the body of this post. Please share this video and stay tuned to our social pages for more alerts on news and case decisions that impact the US Constitution, our nation's founding charter. Thanks so much for joining us.